the person who murdered my mom, and I told her everything she wanted to know to make it happen.
You beat her and you verbally abused her to others. That poor child, your child, Mr. Lane.
You beat him on his day of his death. The rape occurred on the date of his death, and that was brutal and vicious.
In December 2019, Takakota Collins died in Dayton, Ohio, after enduring years of mistreatment. His father, Al Mudahan McLean, called 911, reporting his son was unresponsive. Takakota was rushed to Dayton Children's Hospital, where he was pronounced dead. The investigation revealed that Takakota had been subjected to severe abuse over several years, often confined to an attic and isolated from others.
Mr. McLean was the primary abuser of this child. He beat him on his day of his death. The rape occurred on the date of his death, and that was brutal and vicious.
His case shocked the community and led to multiple arrests, including McLean's fiancée, Amanda Hinsey, and her sister, Jennifer Ebert.
She was every part a complicit, which means to aid, to abet, to assist. Without her spurring him on, without her participating, and when Takakota should be punished and abused, it wouldn't have happened.
In September 2021, McLean pleaded guilty to charges including murder, rape, kidnapping, and child endangerment. He was sentenced to 51 years to life in prison and was ordered to register as a Tier 3 sex offender and a violent offender.
He didn't find peace in life. We are hopeful that this will bring some peace in his death.
Amanda Hinsey also pleaded guilty to involuntary manslaughter and child endangerment, receiving a sentence of 22 to 27.5 years in prison. Her sister, Jennifer Ebert, received 8 to 12 years for her role in failing to protect Takakota. In December 1985, 45-year-old Yvonne Menke was tragically killed outside her apartment in St. Croix Falls, Wisconsin, as she was leaving for work. Her daughter, who lived with her at the time, heard shots and saw someone fleeing the scene. Although suspicion quickly turned toward Mary Jo Bailey, a woman involved in a long-running love triangle with Yvonne and horse trainer Jack Owen, there was not enough evidence at the time to bring charges.
To have those two things snatched away from her by Yvonne was too much to bear. And so she waited outside her apartment on a dark December morning and shot her to death.
The case went cold, with no murder weapon, no DNA, and no surveillance footage available to investigators. The case was reopened in 2021, leading to new interviews and testimony. Witnesses came forward saying Bailey had stalked Yvonne and tried to interfere with the investigation by pressuring others not to speak to the police. She even asked Yvonne's daughter her work hours before her death.
Why does talking about that make you feel emotional?
Because I feel the caller was the person who murdered my mom, and I told her everything she wanted to know to make it happen.
A key piece of evidence was a boot print found in the snow that matched a rare pair of size 5 Arctic Cat boots owned by Bailey.
It was a woman's size 5 Arctic Cat boot. There just are not that many women that were a size 5.
This, along with new accounts of her obsessive behavior, helped prosecutors build a case based on circumstantial evidence.
This case was a lot like a puzzle.
In November 2023, Bailey was arrested in Arizona at the age of 80 and extradited to Wisconsin. Her trial took place in May 2024, and after just 2 hours of deliberation, the jury found her guilty of first-degree murder. On July 2nd, 2024, Bailey, now 81, was sentenced to life in prison with the possibility of parole after 20 years under the laws in place at the time of the crime. On the night of September 19, 2013, Selma police responded to a 911 call reporting a disturbance at a residence on Pinseeker. A concerned neighbor had witnessed a man forcibly dragging a woman back inside the house. Officer Tiffany Kiram was the first to arrive at the scene. As she entered the home, she was shot by the suspect, Jesse Hernandez Jr., a former police officer. Moments later, Officer Jesse Balderramas arrived to provide backup, but was also shot. Despite his injury, Officer Balderramas managed to return fire and wound Hernandez. All three were rushed to San Antonio Military Medical Center for treatment. The incident uncovered a troubling history. Jesse Hernandez had once served as a police officer in Corpus Christi and Robstown, but was dismissed from the Corpus Christi Police Department due to misconduct. During the investigation, his wife, Roseanne Hernandez, testified about enduring years of abuse. She recalled a particularly brutal incident when she was pregnant and was physically assaulted by him. In August 2015, Hernandez was tried for the shooting of Officer Kiram. After just over 2 hours of deliberation, the jury found him guilty of aggravated assault of a public servant.
He had murder in his heart. He wasn't thinking, I just want to aggravate and assault them. He had murder in his heart when he did that. 2 officers gunned down.
Hernandez would face an especially difficult and dangerous time in prison.
In prison, ex-cop equals kill a guy.
After 3 more hours of deliberation, jurors delivered their verdict. Life in prison, the maximum sentence allowed. Hernandez still faces additional charges related to the shooting of Officer Balderramas. Wayne Lee, a 60-year-old man from South Providence, Rhode Island, was known by his family as joyful, organized, and deeply loved. August 6, 2018, an argument broke out between Lee and his girlfriend. Unable to resolve the conflict, she called her son, Richard Price, for help. Price arrived at the apartment along with his own son, Richard Ramos. Tensions rose, and during the confrontation, Lee was injured. Lee was rushed to Rhode Island Hospital with serious injuries and soon fell into a coma. He remained in critical condition until August 15, 2018, when he passed away from his injuries.
He was in a coma. We found out on August 14th, and when the social worker called from the hospital, I guess they weren't aware that he had next of kin here in Rhode Island. The girlfriend knew how to get in touch with us, and she did not give them my phone number.
Lee's family was heartbroken by the loss and demanded justice, believing Price should be held fully accountable.
It's heartbreaking. Can't even shed a tear. I just wanted justice for Wayne. He had bad. He didn't want Wayne to have anything to do with his mother.
A close friend of Price claimed the fatal encounter was never intentional and described it as a tragic accident.
He's still sick. You see the courtroom, he's sick, he's hurt. And I'm sure he's sorry about what happened. Nobody meant to kill anybody. That was just something that just happened. It was an accident.
Initially charged with felony assault, Price's charges were later upgraded to murder following Lee's death.
Dismissing the felony assault and it is being recharged as murder.
Price turned himself into police and is currently being held in custody while awaiting trial. His son, Richard Ramos, was also charged with conspiracy to commit felony assault and released on bail. On the night of January 30th, 2012, 49-year-old Victor Bayz was attacked outside his home in Cranston, Rhode Island. The violence followed a drunken altercation Bayz had earlier with 2 men, Carlos Rios and Carlos Manuel Reyes Sanchez, at a nightclub and later at an afterparty. Bayz had gotten the better of them in that fight. According to investigators, Rios and Reyes Sanchez waited outside Bayz's home. When he appeared, they attacked him. The attack was so brutal that Bayz was left critically injured in the street. He died 4 months later from his injuries.
It was determined the victim was brutally beaten and then intentionally run over as he lay in the street by the vehicle being operated by the suspects.
The suspects fled, but 2 years later, in early 2014, Reyes Sanchez was arrested in Sarasota, Florida, where he worked as a personal trainer. A few months after that, Rios was arrested in Massachusetts after serving time for an unrelated offense. In 2016, both men entered plea deals in a Rhode Island court. Carlos Rios pleaded no contest to second-degree murder and conspiracy to commit murder. He was sentenced to 60 years with 35 to serve. Reyes Sanchez pleaded no contest to conspiracy and was sentenced to 10 years with 6 to serve. In July 2012, a robbery planned by 4 young men at the Arbor Glen housing complex in Providence, Rhode Island, ended in tragedy. The group Russell Burl, Quandel Husband, Donovan Hall, and Timothy DeBrito set out to rob Michael Martin, believing he had marijuana and cash. On the night of July 30th, they met at DeBrito's home and then proceeded to Martin's apartment. According to prosecutors, Burl, Hall, and Husband forced their way inside. During the confrontation, Michael Martin and Damian Colin were fatally shot. Shamika Barros, who was a asleep on the couch, was also killed in the chaos, while Burl, DeBrito, and Hall later accepted plea deals. Quandel's husband chose to stand trial in 2014. His defense argued that the prosecution failed to prove who entered the apartment, casting doubt on husband's role in the killings. They questioned the reliability of witness statements, many of which came from co-defendants seeking reduced sentences. The defense maintained that mere association with the group didn't equal guilt.
Who were those people? Who went in? Was it Beep and Russ and Donovan? Or Russ and Quandel and Donovan? Was it just Russ and Donovan? Or maybe was it Beep with Russ?
Despite these arguments, husband was convicted on 3 counts of first-degree murder and sentenced to 6 consecutive life terms plus 10 years. In June 2017, the Rhode Island Supreme Court overturned his conviction, citing improper and prejudicial testimony that may have unfairly influenced the jury. Rather than face a new trial, husband accepted a plea deal in December 2017, pleading guilty to assault with intent to commit robbery and conspiracy. He was sentenced to 20 years in prison with credit for time already served. In January 2011, a disturbing crime took place in Hopkinton, Rhode Island, involving 30-year-old Jared Teft and his former housemate and ex-ACI cellmate, Peter Newman. According to investigators, Teft assaulted Newman at his home, rendering him unconscious. He then set multiple fires inside the residence while Newman was still alive. Emergency crews later found Newman's body inside the burned home. The case took a decisive turn when Teft's brother, Matthew, alerted police, reporting that Jared had confessed to the killing. Authorities quickly located and arrested him. He was later charged with murder and arson. After years of legal proceedings, Teft reached a plea deal in 2023, pleading no contest to second-degree murder. This spared Newman's family the trauma of a full trial.
I want you to look at my mother. I want you to never forget the pain in her eyes and feel the ache in her heart. I want you to fully understand the pain you have caused an entire family.
At the plea hearing, Newman's sister addressed the court and spoke directly to Teft, sharing the emotional pain her family had endured. She said her brother was a forgiving man, but neither he nor she will forgive him.
My hope is that every day my brother and best friend crosses your mind. My brother was a forgiving person, but this, I know for sure, he would not forgive. I hope that one day God has mercy on your soul, because I never will.
The plea agreement resulted in a 60-year sentence with 40 years to serve and the remaining 20 years suspended with probation. Additionally, Teft received a 1-year concurrent sentence for simple assault. In January 2023, a tragic case emerged from Woonsocket, Rhode Island, involving twin sisters Jennifer and Danielle Pamela and their 70-year-old father, Joseph Pamela. On January 30th, emergency responders arrived at the family's Cato Street home, where Joseph was found unresponsive. His daughter, Jennifer, was discovered nearby in a distressed state and was later taken into custody. Authorities reported that tensions had been growing within the household. Joseph had reportedly discussed plans to sell the home and rehome the family's 12 cats, which may have led to a heated disagreement. Investigators described the living conditions inside the home as poor, with numerous cats kept in cramped cages throughout the residence.
Do you know the extent of his injuries? No. He's dead. Did you know that he died?
Upon regaining consciousness, Jennifer confessed that she had to kill her father. She was charged with first-degree domestic murder. 2 months later, her twin sister Danielle was also arrested after police said she admitted to being involved. Both sisters were later indicted by a Providence County grand jury, not only for murder, but also for conspiracy and animal cruelty related to the condition and treatment of the animals in the home. As of their latest court appearances, both sisters have pleaded not guilty and remain in custody without bail, awaiting trial as the case continues through the legal system. In January 1988, Christine Cole left her home in Pawtucket, Rhode Island to run a quick errand but never returned. After a lengthy search, her body was discovered 54 days later on a beach at Conemacoot Point in Warwick. Despite extensive efforts by investigators, the case went cold and remained unsolved for more than 3 decades. In 2018, the case was reopened by Detective Susan Cormier of the Pawtucket Police Department. During the renewed investigation, a small stain found on the inside inside of Christine's pants was tested for DNA, something that hadn't been done in the original case. The analysis led authorities to João Monteiro, who had lived in the area at the time of Christine's disappearance. Monteiro was arrested in July 2019 and charged with her murder. He was initially held without bail, but later released after posting $5,000 when the state withdrew its objection to bail.
Based on the state's continuing review of the evidence in this case, we can no longer reasonably maintain that request that he be held without bail.
In a January 2020, the murder charge was dropped due to a lack of sufficient evidence directly linking him to the crime.
In shock. It's been a tough 72 hours for him. At least 72 hours. It's been hard. It's been hard on the family, so they're all relieved right now.
Following his release, Monteiro filed a civil lawsuit against the Pawtucket Police Department, claiming wrongful arrest and defamation. In November 2024, the city settled the case, awarding him $1 million. Monteiro has since stated that he hopes to rebuild his life and clear his name fully. In March 2017, 2 undercover detectives from Miami-Dade Police were conducting a surveillance operation near an apartment complex on Northwest 60th Street. They were monitoring suspected gang activity when their unmarked vehicle was suddenly approached, and shots were fired at them. Both officers, Terrence White and Charles Woods, were injured but managed to seek help and were quickly transported to Jackson Ryder Trauma Center, where they were treated and later released. Following the incident, an intensive investigation led detectives to identify Damian "Damo" Thompson, a 19-year-old Miami resident, as a key suspect. Investigators linked him to the case using surveillance footage, tips from the public, and prior contact between Thompson and one of the injured detectives. On March 29th, authorities located Thompson at a hotel near Miami International Airport. During the arrest, he allegedly resisted and made verbal threats, but the officers were able to take him into custody safely.
2 counts of attempted first-degree murder. The other case, 2 counts of battery on a law enforcement officer, 2 counts of resisting an officer with violence. Those are your charges. I'm appointing the public defender's office for you.
Thompson was charged with 2 counts of attempted first-degree murder, along with battery on law enforcement and resisting arrest with violence.
He had just fired at 2 Miami-Dade police officers when the 2 brave Miami-Dade police officers then risk their lives in order to take this dangerous individual into custody, and he continues to threaten police officers during the course of his apprehension.
He made threats that he was going to kill these officers while they were trying to arrest them. So there's probable cause for 2 counts of battery on a law enforcement officer. No bond count 1, no bond count 2.
In court, Thompson was denied bond and ordered to remain in custody. Prosecutors described him as a danger to public safety and noted his alleged ties to a local gang. He was also identified as an aspiring rapper with a presence on social media. In October 2021, Manuel Perez, a homeless man in downtown Miami, was tragically killed while sleeping on a sidewalk. Though surveillance footage captured a possible suspect near the scene, no arrests were made at the time, and the case remained open. 2 months later, on December 21st, 2021, 2 more homeless individuals were targeted in similar attacks. Around 8 p.m., a man was critically injured after being shot near Southwest 2nd Avenue. Roughly 2 hours later, another man, identified as Jerome Price, was found dead at Miami Avenue and 21st Street. He too had been shot while resting in a public area. Investigators noticed a pattern. All 3 incidents involved homeless victims, occurred at night, and happened in public spaces. Surveillance footage captured a black Dodge Charger near the scenes. A partial license plate led detectives to Willie Suarez Mo, a 25-year-old real estate agent from Miami. When police found Maceo, he was carrying a loaded handgun. Ballistic testing linked that firearm to shell casings found at the December crime scenes. Further investigation connected Maceo to the October murder of Manuel Perez. With this evidence, Maceo was arrested and charged with 2 counts of first-degree murder and 1 count of attempted murder.
Mr. Willie Maceo is charged with 1 count of attempted premeditated murder.
Authorities described the crimes as targeted and deeply troubling due to the vulnerability of the victims.
The investigators took no rest. They knew they were close. They felt the pain. They felt the injustice that the victims had suffered at the hands of this cruel individual and this senseless crime. And through their diligent efforts, were able to successfully apprehend a violent criminal that's no longer on the streets of Miami.
At a court hearing on Christmas Eve, Maceo's defense attorney argued there was no direct video showing him committing the acts. However, based on ballistic and circumstantial evidence, the judge denied bond and Maceo was ordered to remain in custody. In August 2009, a tragic incident shook the town of North Kingstown, Rhode Island, when Camden Fry was found unresponsive in her bed. Her mother, Kimberly Fry, had been struggling with parenting stress and mental health challenges, which she discussed during therapy sessions earlier that year. On the night of August 10th, her husband left for a hockey game, leaving Kimberly and Camden alone. The next morning, Camden was found lifeless, and Kimberly appeared distressed. Authorities later arrested Kimberly and charged her with second-degree murder. During her 2011 trial, prosecutors argued that Kimberly caused Camden's death during a conflict over bath time, while the defense claimed it was an accident during an attempt to restrain the girl. Kimberly was convicted and sentenced to 40 years in prison with 20 years to serve. She appealed the conviction, but the Rhode Island Supreme Court upheld it in 2016. A later request for post-conviction relief was also denied. In August 1990, 85-year-old Germaine Mushon was found dead in her West Warwick, Rhode Island apartment. Her grandson, Richard Mushon, had gone to pick her up for a family event, but instead discovered her body. The scene showed signs of a struggle, but there was no forced entry. The medical examiner noted bruises and collected biological evidence. Despite early investigation, the case eventually went cold. For 25 years, the murder remained unsolved. Then, in 2015, Detective Thomas Nye reopened the investigation. With advances in forensic science, the preserved DNA evidence was retested. The results matched David Roscoe, a man with a criminal history, including child molestation. A new DNA sample was collected from Roscoe to confirm the match. In December 2015, Roscoe was indicted and arrested for the sexual assault and murder of Germaine Mushon. He was held without bail and went to trial in 2016. A jury found him guilty, and he was sentenced to life in prison. However, in 2019, the Rhode Island Supreme Court overturned the conviction. The court ruled that Roscoe's right to a fair trial was violated when the judge allowed a detective to testify about statements from 3 witnesses who had died and could not be cross-examined. Rather than face a new trial, Roscoe entered a plea deal. He pleaded no contest to second-degree murder and was sentenced to 40 years, with 20 to serve and 20 suspended on probation. The sexual assault charge was dropped. In the early hours of January 16, 2025, a troubling incident occurred in downtown Miami involving multiple individuals experiencing homelessness. Around 5:45 a.m., surveillance footage captured a man approaching people sleeping along Northwest 6th Street and North Miami Avenue. The man, later identified as Brenton Clark, 36, from Inwood, New York, was seen carrying sticks that he used to confront and harm individuals who were resting on the sidewalk. Witnesses say he moved between different locations nearby, where more people were affected by his actions. One bystander intervened, prompting the suspect to leave the area. Police responded quickly and located Clark a few blocks away. He was taken into custody after a short chase and brought in for questioning. 2 of the victims sadly passed away, while 2 others were hospitalized and continue to recover. Clark was formally charged with 2 counts of first-degree murder, 2 counts of attempted murder, and robbery. During his court appearance, he was ordered held without bond. On February 6th, he entered a not guilty plea. Authorities described the case as deeply unsettling, especially because the victims were among the city's most vulnerable residents. The Miami-Dade Homeless Trust and local officials praised the swift police response and called for continued support for those experiencing homelessness. On the evening of October 12, 2024, what began as a festive night at the Harvest Homecoming in New Albany, Indiana, ended in heartbreak. Around 9:50 p.m., fire broke out near State and Black streets, sending crowds into panic. Amid the chaos, 18-year-old Bryce Gerlac, a high school senior and football player from Corydon Central, was shot and died at the scene. 2 others, a 22-year-old man and a 42-year-old woman, were also injured but survived. All 3 were later confirmed to be innocent bystanders, caught in the middle of a violent dispute between 2 groups. Bryce's death shook the community. Described as kind, selfless, and protective, some believed he may have died trying to shield others. His school held vigils, and his memory was honored by friends, classmates, and neighbors who remembered him for his courage and heart. As the investigation unfolded, arrests began. On October 27th, police apprehended Joshua Smith, a 20-year-old from Louisville. He admitted to firing a gun at the festival, claiming he had only fired into the air. He was charged with criminal recklessness, obstruction of justice, and resisting arrest. But the investigation soon revealed a wider network of suspects. In the following weeks, police arrested Darius Tuff and Shermichael Smith, both in their 20s, on charges of murder and conspiracy to commit armed robbery. Another man, Isaiah Page, was charged with attempted murder. Ballistic evidence, surveillance footage, and phone records helped authorities connect the suspects to the crime scene. A fifth suspect, Demarius Person, was later charged with allegedly encouraging the violence and helping others get to the location. On March 28, 2025, Joshua Smith appeared in court. That same day, Bryce's family faced Smith in court for the first time. His mother, Heather Gerlac, read an emotional statement describing their loss and the lasting pain of losing her son. She spoke directly to Smith, sharing what Bryce meant to their family and the future that was taken from him.
It has been over 5 months since we've heard Bryce's voice, seen his smile, or felt his presence. Every day feels like an eternity without him. The absence of his laughter, energy, leaves a hole in our heart that will never be filled. The pain of not having him here to share future moments is a burden we will carry forever. Bryce's last breath was taken on October 12, 2024, around 9:50 p.m. That moment is etched in my soul and marks when our world was shattered. We are stuck in that moment and unable to move past it. Our lives, as well as those of his friends, have been destroyed. On the night of Bryce's murder, he was an innocent bystander, living his life when Joshua Smith chose to bring violence to Harvest Homecoming by pulling out a gun and firing several shots. We believe that in Bryce's final moments, he acted as a hero. His selflessness, bravery, and instinct to help others, even in the face of danger, are a testament of the incredible person he was. While everyone else ran, Bryce fought for his life, eventually dying in the right area. He did not have a chance to be taken to the hospital. We were denied the opportunity to say goodbye to Bryce in a dignified manner. The impact of Bryce's death has rippled through his school, his team, and our entire community. His friends, coaches, and classmates will never get the chance to see him fulfill the bright future he deserved. We will never see him walk across the graduation stage, play his final football game, or even laugh. It is an unfathomable fate, and those who loved him will must face the rest of our lives. Bryce's siblings, Bella and Owen, have lost their best friend and brother. The pain, confusion, and overwhelming grief that they carry every day is something no one should ever have to endure. They will never have the chance to grow old with Bryce, share their lives with him, or experience the special bond they had. That loss is beyond measure. If Joshua Smith had not brought violence to Harvest Homecoming, a place filled with family and children having fun, Bryce would still be here today. As the prosecutor made a deal with Joshua, I can't help but feel the injustice of it all. No deal will bring Bryce back, and no testimony will undo the damage done to our family and friends. Joshua Smith and his friends went to Harvest Homecoming with Bryce, knowing they were going to fire shots, showing no regard for anyone's life but their own. They ran while Bryce lay dying. Bryce didn't deserve this. No one deserves to have their life taken away so senselessly. I asked for justice for Bryce. I asked the court to remember Bryce as the innocent, loving, and talented young man he was, with dreams and aspirations that will never be realized. I ask that you take into account the irreversible damage caused by the actions of Joshua Smith. He made it a choice, and that choice cost my son his life. Justice for Bryce is not just about punishment, it is about acknowledging the immense loss of his death has caused to our family and ensuring that no one else has to experience the pain we now live with every single day. We as a family believe that Joshua Smith should have received no less than what Bryce received, which would have been life in prison. Bryce will never get to experience the life he dreamed of, but through this process, I hope Bryce's memory can live on, not only as a reminder of the pain of his loss, but the testament of the kind of person he was, someone who made the world a better place by just being in it. To Joshua Smith, your involvement in the murder of my son has destroyed the lives of his family and friends. Bryce's loved ones are left grappling with the irreplaceable loss, struggling with the pain his absence every day. Your actions left scars that will never heal, leaving a void that no amount of time can fill. You will have the opportunity to live your life one day, to see your family, to experience moments that Bryce never gets to. You will have the chance to see your mother again, to walk out of prison and to continue your life. But Bryce will never have that chance to see his family, to hug me, to laugh with his siblings. Bryce will never get to experience the future he should have. It is hard to comprehend the depth of devastation you've caused, but it is clear that your choices have shattered the world of those who loved my son. Bryce Gerlac.
Smith accepted a plea deal. Though originally facing 11 charges, including murder, he pleaded guilty to conspiracy to commit armed robbery. In exchange for his cooperation and testimony against the others, he received a sentence of approximately 8 years, with credit for time served and 2 years suspended under supervised probation. On the night of October 2nd, 2022, Eric Cantou was sitting in his maroon BMW in a McDonald's parking lot in San Antonio, Texas, eating a hamburger with his girlfriend, Emily Pro. Officer James Brennan, a probationary officer with the San Antonio Police Department, SAPD, approached the vehicle. Brennan believed the car matched one that had fled from him the previous evening and suspected it was stolen because of mismatched license plates, though it was later confirmed the vehicle was not stolen. Without identifying himself as a police officer, Brennan abruptly opened the driver's side door and ordered Cantou to step out. Startled, Cantou reversed the vehicle to flee. As he did, Brennan opened fire. Cantou was hit and suffered serious injuries. His girlfriend was unharmed. Cantou was placed on a ventilator and remained hospitalized for several weeks in critical condition.
Get out of the car.
The incident caused public outrage. SAPD quickly fired Brennan for violating department policies and procedures. Initially, Cantou was charged with evading arrest and assault on a peace officer, but those charges were later dismissed. In December 2022, a grand jury indicted James Brennan on 2 counts of aggravated assault by a public servant and 1 count of attempted murder. Over time, legal developments shifted. In March 2024, the attempted murder charge was dropped and replaced with a lesser charge, deadly conduct, a third-degree felony. In April 2024, Cantou and Emily Prue filed a civil lawsuit against James Brennan and the city of San Antonio. The lawsuit claimed Brennan used excessive force and that Cantou feared for his life, believing the carjacking was a robbery, not a police encounter. As the criminal case against Brennan moved toward trial, both sides faced delays due to evidence and procedural issues. Jury selection was scheduled for April 11th, 2025, with testimony expected to begin on April 14th. However, on March 26, 2025, during a court hearing in the 226th District Court, both the prosecution and defense requested a joint continuance.
Quiet, please.
Okay, 2024 CR 2701, State versus James Brennan. He is present. Okay, will the attorneys please state their names for the record?
Neil Cordero for the state of Texas.
Nicole Thornbrook for the state. Thornbrook for the state.
Jay Norton. Okay, and sir, are you James Brennan?
Yes, Your Honor.
Okay, so counsel, let's see, the state filed a motion, so state, you go first.
Judge, this is an agreed motion filed by both parties, an agreed motion for continuance. Both parties are asking the court to continue this case for the reasons stated in the motion. Orally, we can just represent to the court that defense counsel has requested or is needing time to evaluate new experts that they have begun to evaluate as of last Friday. At least that's when we became aware of that. Further, we have requested the internal affairs files for all of the San Antonio police officers that were involved in this case. The city has quashed that subpoena. Both parties are seeking a continuance to sort that issue out. And further, we are in agreement with this continuance so that the discovery process can continue in good faith.
Okay, and defense?
Judge, I would just echo the same sentiments that Mr. Cordero did and say that I think the prosecutors on this case are trying to do the right thing by way of discovery, and I don't want to put them in a bad situation with since the intention is to do the right thing, and we concur.
Okay, so just to make sure, you're seeking additional experts regardless, correct? And you need more time to be able to consult with them, is that?
Yes, sir.
Okay. And then the state, you've issued subpoenas for those IA files?
We have, Judge.
And there's presently a City of San Antonio motion to quash those subpoenas?
Yes,
correct?
Judge. It was filed, I believe, last week on Friday.
Now, that's pending, correct?
It is pending, and we're going to need some time to
sort that out? Okay, and in addition, you are seeking additional discovery as part of your continuing good faith effort to provide the defense with discovery?
Yes.
Okay, and Mr. Brennan, I see that you have your signature affixed to this motion. Well, yeah, is that your signature there, sir?
Yes, Your Honor.
And you're in agreement with this request to continue the case?
Yes, Your Honor.
Okay, then we'll go ahead and grant that motion. This case had been set for trial, jury selection April 11th and trial on April 14th, so those will be canceled. And now, do you all have any idea now when it is that you want to have this scheduled, or do we need to reschedule for a setting? Because otherwise, I don't want it to fall through the cracks, and we just let it go in limbo. So, can we schedule? Like, when would you know when you want to go to trial?
Judge, I think next Friday we can have a status hearing to determine a new scheduling order.
Will that give you enough time to at least resolve some of these issues?
Probably not, Your Honor, but in a week, at least from the City of San Antonio perspective. But that would give us time to kind of herd the cats and get all our calendars together.
Okay, so reset. What's next Friday?
April 4th for a status hearing.
Okay, so we're set for next.
Just a minor thing. I have something on April 4th that I kind of can't miss. I don't really want to put it on the record, but
that's fine.
If we could do, say, 10 instead of 9, that would be very helpful.
So Friday, April what, I'm sorry? April 4th, is that what you said?
It was set for April 4th.
Okay, April 4th, 2025 at 10 a.m., okay?
Thank you, sir.
Okay, anything else from your side?
Nothing.
Let's get a motion is signed. You all can get copies of it at some point, okay? Thank you very much.
Thank you, Judge.
Defense counsel cited the need to consult new expert witnesses, and both parties were also awaiting access to internal affairs files of officers involved in the case, files the City of San Antonio had moved to quash. The judge agreed to the continuance and canceled the trial dates. As of now, the trial of James Brennan remains pending. In November 2011, DeAndre Lane took temporary custody of his daughter, Bianca Jones, with plans to care for her until Christmas. On the morning of December 2nd, 2011, Lane called 911 and reported that his vehicle had been stolen in a carjacking and that Bianca had been inside the car when it was taken. The vehicle was located shortly after, but Bianca was nowhere to be found. Lane told authorities that 2 armed men had taken his car while he was stopped at point. However, his story quickly drew suspicion. Investigators noted inconsistencies in his account, and a cadaver dog later signaled the presence of human remains in both the car and Bianca's bedroom. As the investigation unfolded, more disturbing details came to light. It was revealed that Lane followed an unusually strict parenting style. Witnesses shared that he was intensely focused on discipline, particularly regarding toilet training. Prosecutors alleged that DeAndre Lane became extremely upset after Bianca had an accident during toilet training and responded with harsh punishment. They believe he later created a false story about a carjacking to hide what had happened. Though Bianca's body was never found, the evidence, largely circumstantial, pointed strongly to foul play. Lane was arrested and charged with felony murder and child abuse. In October 2012, after weeks of testimony and legal arguments, a jury found Lane guilty on both counts. During sentencing, the judge addressed Lane's actions with strong words, highlighting the controlling behavior he exhibited and the emotional toll it took on those involved.
Did a very good job in presenting the evidence in this case. It was very circumstantial. There was a lot of evidence that had to be reviewed, and both sides did a very good job in putting forth their respective positions. However, this is the time the court has an opportunity to make its statement about what it believes was presented and to ultimately sentence the defendant. This case is about a man who wanted to control others but who could not control himself. Your kingdom consisted of exploiting women who you controlled and children who you excessively disciplined. Your tools, manipulation, mental abuse, and excessive discipline with your children. It was your way or the highway. But what you could not control was a small child that was incapable mentally and physically of controlling her bowels and urine. So you decided to make an example out of her by punishing her for what she had no control of. You beat her and you verbally abused her to others. That poor child, your child, Mr. Lane, you destroyed mentally and ultimately physically. When she died, you had to devise a plan, a way to escape what you had done. You carried her around and controlled her dead body like a rag doll. Please be seated, Mr. Johnson, while I'm talking.
I'm sorry.
That's very disrespectful. Mr. Lane, I need you to be quiet or I will impose sentence with you in the lockup. Carrying her around and controlling her dead body like she was a rag doll. Putting in her car with no food or diapers. Ultimately lying about her disappearance as a carjacking. My father always said, never lie because you have to remember the 100 lies you told to cover up the first lie. You figured that a city plagued with violence, understaffed by police, who would care about the disappearance of your child? But you were wrong. You were wrong. Not only was law enforcement, but regular individuals who thought about your child, who wanted your child to have a proper burial, scoured these streets day in, day out without receiving a proper compensation, many of them doing it, the citizens doing it for free, law enforcement, volunteering, taking them away from their families. For what? For this lie that you concocted because you were not man enough to face up to what you had done. You disciplined that child, you tortured that child, and you should be ashamed of yourself. When law enforcement questioned you, you had selective memory. You remembered every detail about everything except what was really important, and that was who and why you let someone take your child. Absolute control controls absolutely.
Lane interrupted the proceedings to protest his innocence, which led to a brief removal from the courtroom.
And now you will face what you tried to escape. By discarding a priceless child's life, you will now pay with your own life. At this time, as to count 1 felony murder, the court is going to sentence you to the maximum punishment of mandatory life without parole. As to child abuse first degree, as well as the fact that you've been charged with a habitual offender notice, the court is going to sentence you, excuse me, sir, to no less than 11, no more than 30 years in prison. The court is going to give you 246 days credit. You have 42 days to appeal my decision. If you cannot afford an attorney, want to be appointed to you, take him out. That concludes this matter.
He was ultimately sentenced to life in prison without the possibility of parole for felony murder, along with an additional term of 11 to 30 years for the child abuse charge. Despite Lane's continued claims of innocence and the absence of Bianca's remains, the court concluded that the evidence painted a clear picture of what had occurred. On the morning of August 3, 2019, 21-year-old Patrick Crucius left his hometown of Allen, Texas, and drove nearly 10 hours to El Paso. His destination was a Walmart near the U.S.-Mexico border, a location known for its popularity among the local Hispanic community. Just before lunchtime, he entered the busy store with a semi-automatic rifle and opened fire. Within minutes, 22 people had lost their lives, and 24 others were injured. Families were caught off guard, many simply out shopping for school supplies. The scene was chaotic and heartbreaking. Crucius soon surrendered without resistance to officers stationed nearby. In the hours that followed, authorities discovered a document online believed to be written by Crucius. In it, he expressed deeply troubling views, including anti-immigrant and white nationalist beliefs, and admitted he was specifically targeting Hispanics. Federal agents quickly classified the act as a hate crime. The FBI and Department of Justice launched a joint investigation, treating the shooting as one of the deadliest racially motivated attacks in recent U.S. history. In October 2019, Crucius appeared for his first court hearing in El Paso's 409th District Court, accompanied by his attorneys, Mark Stevens and Joe Spencer. He entered a plea of not guilty to 22 counts of capital murder.
This is cause number 2019-04878, the state of Texas versus Patrick Wood Crucius. We are here for an arraignment. May we have announcements of counsel?
Your Honor, the state is ready.
Good afternoon, Your Honor. Mark Stevens and Joe Spencer, if you have the defendant ready. Sir, do you are Patrick Wood Crucius, the defendant in this case? Yes, Your Honor. Raise your right hand for me, please. Do you swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I swear.
First, I want to make sure, am I saying your name correctly?
Yes.
Okay. Sir, you've been charged by indictment with the offense of capital murder with multiple persons. I'm handing you and your lawyer a copy of the indictment. I do need you to look at the indictment. I need to make sure that your true, full, complete name is on that indictment.
Yes, there it is.
Sir, would you like to have that indictment read to you, or do you wish to waive reading of the indictment?
I should waive.
And to the indictment, sir, do you wish to enter a plea of guilty or not guilty?
Not guilty.
The court has entered a plea of not guilty on your behalf. I am scheduling, this matter has already been scheduled for a conference setting November 7th, 2019 at 2 o'clock in the 409th District Court. Are there any other matters that need to be taken up before we conclude this hearing?
No, Your Honor, not on behalf of the state. Not from me, essentially.
Very well. Having given you a copy of your arraignment, having entered a plea of not guilty on your behalf, we are concluded, and this matter will be taken up again November 7th, 2019 at 2 o'clock. We are adjourned.
All rise.
This was despite law enforcement stating that he had cooperated during questioning and admitted his motive. A few months later, in February 2020, a federal grand jury indicted Crucius on 90 counts, including hate crimes resulting in death, attempted murder, and use of a firearm in a violent federal crime. These charges opened the door to the possibility of the death penalty, although federal prosecutors delayed a decision on that for several years. During this time, Crucius remained in solitary confinement and was placed on watch due to concerns for his safety and mental health. After years of pre-trial motions and delays, Crucius changed his plea.
Under cause number 2020-0D0-2631 to the offense of capital murder as alleged in the indictment, do you wish to enter a plea of guilty or not guilty?
Guilty.
And under cause number 2023-0D0-5832 to the 22 counts of aggravated assault with a deadly weapon as alleged in the indictment, do you wish to enter pleas of guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
Mr. Montoya, what is the plea agreement in these cases?
Your Honor, in exchange for the defendant's plea of guilt and a complete waiver of his appellate, post-conviction, and any potential executive clemency, the state is withdrawing its notice of intent to seek the death penalty in the 2020 cause number for a sentence of life with no possibility of parole. And then, Judge, with respect to the 2023 cause number, it is 22 counts of aggravated assault enhanced with a bias and prejudice finding, bumping those up to first-degree felonies. And so we would, 22 counts of life.
Of life?
Yes.
Mr. Crucius, I overlooked the fact that they were enhanced, so the range of punishment for the 2023 cause number is confinement in the institutional division of the Texas Department of Criminal Justice for a term of life or 99 years, but no less than 5 years, and a fine not to exceed $10,000. So the 2 to 20 I talked about earlier has been enhanced to that. Do you understand this?
Yes, Your Honor.
And is it still your intention to plead guilty to the 2023 cause number, knowing what the range of punishment is?
It is.
Okay. And you said it's going to be life on all 22 counts?
Yes, sir.
Mr. Stevens, Mr. Spencer, Mr. Valenzuela, is this your understanding of the plea agreement?
It is, Your Honor.
Sir, is this your understanding of the plea agreement you've reached with the state of Texas?
He admitted guilt to the federal charges, accepting full responsibility for the attack.
Based on the evidence presented here today and on your pleas of guilty, I will accept your pleas and at this time find that the evidence does substantiate your guilt. In cause number 2023-0D05832, I do find you guilty of 22 counts of aggravated assault with a deadly weapon that has been enhanced to first-degree felonies. And under each count, I hereby sentence you to confinement in the institutional division of the Texas Department of Criminal Justice for life terms. In cause number 2020-0D02631, I do find you guilty of capital murder, and I sentence you to confinement in the institutional division of the Texas Department of Criminal Justice for a term of life without the possibility of parole. Have you understood everything that's happened?
Yes, Your Honor.
In July 2023, he was sentenced to 90 consecutive life terms in federal prison, ensuring he would never walk free again. Although he received multiple life sentences in federal court, the state of Texas has kept its capital murder case open. It still reserves the right to pursue the death penalty under state law. As of now, that trial has yet to be scheduled. Edward Madak, a respected figure in California basketball, served as Fresno City College's men's basketball coach for 14 seasons. During his tenure, he built a legacy with a 397-70 record, secured 2 state championships, and helped over 100 players earn scholarships to 4-year colleges. In February 2020, Madak was placed on administrative leave due to alleged violations related to team benefits, such as providing players with snacks and organizing team barbecues. He challenged the accusations, and by the end of 2021, a judge dismissed the case. While he was reinstated as a faculty member, he did not return to coaching. In June 2022, Madak took up a brief coaching role at Buchanan High School, but resigned just 6 months later in December, citing personal reasons and a desire to spend more time with his family. On August 15, 2023, while conducting a class at Fresno City College, Madak reportedly made troubling remarks during a PowerPoint presentation, including a vague reference to bullets flying towards students. Some students claimed he mentioned having a firearm and made threatening comments about harming college officials, specifically naming Chancellor Dr. Carol Goldsmith. Following the reports, the college placed Madak on administrative leave.
They believed that through investigation that Mr. Madak made threats that he would shoot up the school, that the bullets on the PowerPoint were flying towards students.
He was arrested on October 13th, 2023 in Merced County and booked into Fresno County Jail. He was later released on bail. The case gained attention as prosecutors alleged he had made criminal threats toward the chancellor. The students were stunned when they heard the news.
I found out about it this morning because my friend sent me a picture of an actual PowerPoint or whatever explaining that all of this happened. So I didn't know about this until literally today, this morning.
One thing that surprises me is that the school waits 2 months before publicizing this.
During the preliminary hearing, Chancellor Goldsmith testified about the fear the remarks caused her, but defense attorney Robert Carroll questioned the credibility of the case, pointing out that several students did not remember any threatening statements. The defense also criticized the investigation for lacking thoroughness.
We don't even know what was said, but even if under the best of circumstances, the best that they have is threatening language at best.
On January 28, 2025, Judge Brian Alvarez dismissed the charges, ruling that the evidence did not establish probable cause.
This is one of those cases where it just didn't rise to the occasion of probable cause, and so frankly, for that reason, he is discharged.
He stated that while the remarks were concerning, there was no clear intent for them to be received as threats by the chancellor.
I have not heard any evidence that Mr. Madak intended his statement be communicated to the chancellor.
I just want to move on with my life and get my life back.
Although the criminal case was closed, Madak's professional struggles continued. In July 2024, Fresno City College terminated his teaching contract. He is currently appealing that decision. Testimonies from mental health professionals during the administrative hearings have described Madak as emotionally distressed, but not a danger to others. As of now, the criminal charges have been dropped, but the outcome of Madak's appeal for reinstatement at Fresno City College remains undecided. Between December 16th, 2024 and January 2nd, 2025, Michael Thomas Lewis Jr., a 55-year-old man from Denton, Texas, began a disturbing campaign of harassment targeting WNBA star Caitlin Clark. Over this period, Lewis used the social media platform to send explicit and threatening messages to Clark. His posts referenced driving past her home repeatedly and hinted at attending her games, despite being banned from some venues. These actions caused Clark to feel threatened and fearful, prompting her to change her routine and take extra precautions for her safety. The situation escalated when the FBI and local authorities traced the origin of the threatening messages to Lewis's internet activity at a Hilton Garden Inn hotel and the downtown Indianapolis Public Library. On January 8, 2025, Indianapolis police located him at the hotel. When questioned, Lewis claimed he was on vacation and that his messages were fantasies or jokes, denying any intent to harm or intimidate Clark. Despite receiving a prior warning from law enforcement, Lewis continued his threatening behavior. As a result, on January 13, 2025, he was arrested and formally charged with felony stalking. Prosecutors emphasized that Lewis had deliberately traveled from Texas to Indiana to be close to Clark, and they requested a higher than usual bond due to the severity of his actions and the fear they caused.
Morning, Mr. Lewis.
Guilty as...
No, sir. This is initial hearing.
Oh.
We are not. You have a right to remain silent, and I expect you to exercise that. Okay, this is just telling you what the charges are. You do not listen. I'll give you a chance to talk. It's not your time.
Throw me the bookie.
Stop talking. You have a right to know what your charges are. You are charged with stalking as a level 5 felony. All right, they are alleging level 5 felony carries 1 to 6 years in the Department of Corrections with a presumptive sentence of being 3 years. They are alleging that on or about December 16th, 2024 and January 11th of 2025, Michael Thomas Lewis Jr. did stalk another person, to which Caitlin Clark, by engaging in a knowing or intentional course of conduct involving repeated or continued harassment of Caitlin Clark that would cause a reasonable person to feel frightened, intimidated, or threatened, and that actually caused Caitlin Clark to feel frightened, intimidated, or threatened, and did make an implicit or explicit threat with the intent to place Caitlin Clark in reasonable fear of sexual battery. That's the charges. Do you understand the charges against you? Not yet.
Michael Lewis
lassos Clark. No, I'm asking you. Do you need an attorney? Are you planning to hire one?
I need medication.
You also might need that, but
They can give me my medication.
Perfect. All right. So do you suffer from mental illness?
I need my medication.
And what medication are they not giving you?
Trazodone.
During his initial court appearance on January 14, 2025, Lewis behaved erratically. He repeatedly interrupted the judge, proclaimed himself guilty as charged, and stated he hadn't received his medication while in custody. Judge Angela Davis entered a not guilty plea on his behalf and assigned him a public defender. Lewis also expressed that he preferred to remain in jail and had no intention of posting bond.
Do you understand? And I'll give you a copy of it to make sure that you understand. You are to have no contact with her whatsoever. Direct, indirect, You cannot call her under your PIN number, anyone else's. You may not contact her via any social media or text or phone or computer. Do you understand that?
Yes.
You are also to stay away from Gainbridge Fieldhouse and Hinkle Fieldhouse.
Yes.
That's fine as well.
Okay. Is that within 500 feet or 1,000?
I don't know. I asked the court for clarification because Gainbridge is downtown. I think you're going to be a quarter mile away from it if you're just on the highway. He's in custody right now. It doesn't matter. But
I'll do 500 feet. But you cannot go in the building. Cannot walk by. Cannot park outside of it. You need to give your phone number and whatever address you have. Because if you post bond, you will be on GPS. There will be a hold for pickup, which means they will put an ankle monitor on your foot, and they will know your whereabouts. If you violate either the stay away order or the no contact order, your bond, and it's proven by a preponderance of the evidence, or if you try to contact her again, the court will revoke your bond. If you violate the no contact order in the jail or out, they can file an invasion of privacy. You have now been told by the court you may have no contact with her of any kind. Your bond is set in the amount of $50,000 surety. That's $5,000 to a bondsman, and you must remain in the state of Indiana unless you get permission. You will be on GPS. You will not be allowed near Hinkle Fieldhouse, near Gainbridge Fieldhouse, or near Caitlin Clark. Do you understand? You can go anywhere else you want other than those places.
Yes.
The court imposed strict conditions in the event Lewis chose to post bail. His bond was set at $50,000, and he would be required to wear a GPS ankle monitor, remain in the state of Indiana, and avoid any contact with Caitlin Clark. He was also ordered to stay at least 500 feet away from Gainbridge Fieldhouse and Hinkle Fieldhouse, locations associated with Clark and her personal life. If convicted of the level 5 felony stalking charge, he faces a prison sentence ranging from 1 to 6 years and a fine of up to $10,000. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.